and it's the honor of my life to represent Mr. Comey in this matter. Oh gosh, what is wrong with you? I think that October 20th schedule, I would suggest, would be for the first tranche of defense motions, which would principally consist of a vindictive prosecution motion, which is rich, coming from Comey, who rigged intelligence reports to go after Trump, or the government has within its power to declassify documents and take that issue away altogether and turn that information over in the regular course of discovery, which is what I really hope they do. Just declassify it all, let us see it, file it openly on the public docket. James Comey arraigned in court. Big one, since he's the former FBI director now facing criminal charges for lying to Congress. He showed up in court with his attorneys. We've got the full transcript on everything that went down. It's not a long hearing because it's just very basic and preliminary, but it's 21 pages. And in court were the following people for the United States government in the case of the United States of America versus James Comey out of the Eastern District of Virginia. We have Lindsay Halligan, appearances please, for the DOJ, Nathaniel Lemons, Gabriel Diaz, all for the people. On the defense, representing James Comey, we've got Ellis and Brock, Jessica Nicole Carmichael, Patrick Fitzgerald, and can we shout out our court reporters? Man, we love our court reporters. Diane Salters was awesome yesterday. Thank you, Diane, for getting us the materials. So here is what we have. Courtroom deputy is ready to call the case. Courtroom's mumbling. Breakfast. I couldn't park. Find parking. Where'd you park? Blah, blah, blah. All the things. Courtroom deputy comes in. Time is set for United States versus James Comey, case number 25CR272. Will the parties please note their appearances for the record? Mr. Lemons for the DOJ. Good morning, Your Honor. Tyler Lemons here for the United States government. Lindsay Halligan says. Lindsay Halligan. Mr. Diaz. Good morning, Your Honor. Gabriel Diaz here for the United States. And the judge says, good morning. The defense. He looks over to their table. Good morning, Your Honor. Pat Fitzgerald. And it's the honor of my life to represent Mr. Comey in this matter. Oh gosh, what is wrong with you, dude? It's an honor of my life to represent Comey. Did you guys make out just 2 minutes ago? What are you doing? Of course, judge is like, good morning. Okay. Looks to the other attorney. Miss Carmichael says, good morning, Your Honor. Jessica Carmichael for Mr. Comey. No weird slobbering love affair from her. Thank you, Jessica. Judge says, all right, good morning, everybody. Good morning to you all. Thank you for being prepared. This is the Eastern District of Virginia. 10 o'clock arraignment often will start at 9:55. Now, this matter comes for arraignment this morning. Because this is Mr. Comey's first appearance in court, however, we will go through the formalities of the initial appearance, pursuant to Rule 5 of the rules. The purpose of the initial appearance is to advise the defendant of the charges contained in the indictment, the potential penalty for those charges, notify the defendant Comey of certain constitutional rights, and the right to counsel. Now, first, I want to advise you, Mr. Comey, if you will stand. Comey stands up, that you have the right to remain silent and that any statements you make may be used against you. You also have the right to an attorney, and if you cannot afford an attorney, one will be appointed for you. The record reflects, of course, that you have retained counsel and your counsel are present with you this morning. With respect to the indictment pending against you, you have been charged with 2 counts. Count 1 charges you with false statements within the jurisdiction of the legislative branch in violation of U.S. law. Count 2 charges you with obstruction of a congressional proceeding, also in violation of U.S. law. The maximum penalty for both offenses are 5 years imprisonment and a fine of up to $250,000. Now, let me confirm that you understand your rights and the charges pending against you. Comey responds, I do, Your Honor. Thank you very much. Okay, so that's a huge component of the arraignment, is just to make sure the charges are out there in the air. They're arraigned out and you know what they are, so you have proper notice. And this is a key component of due process, so that if you're being prosecuted, you got to know the nature of the offense against you. You got to understand it. You do? Great. Thank you. Now, turning to the arraignment itself, let me ask defense counsel, if you've received a copy of the operative indictment, did you have all the materials? That is docket entry number 1. And have you had an opportunity to review the indictment with your client? So they're aware. Yes, Your Honor. We have received the indictment. I have reviewed it with my client. My client wishes to waive a public reading. So that would be the formal reading of the indictment. He says, we've already read it. We don't need to read it again. So we waive that. My client wishes to enter a plea of not guilty. Come on. And my client asks for a jury trial, right? So this attorney just kind of bundled it all up into one response. Bop, 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 bop. Very good. Have you calculated the speedy trial deadline in this matter? Defense says, yes, we have, Your Honor. And as it currently stands, I believe December 17th appears to be the date without any exclusions. If we just have a trial by there, because sometimes you'll have a continuance, and during the continuance, you'll waive time, so that won't count against the clock like on the chessboard. Yeah, very good. That is the date the court has also calculated, December 17th. So let me confirm that the government agrees that the speedy trial deadline would be on the 17th. Is that right? Looks to the prosecutor. Yes, Your Honor. We agree. All right. Do the parties believe the case can be tried within the speedy trial deadline? Can we get this done before December? Defense. Your Honor, it could, but we would like to propose a trial date. Now, I think I'd like to give Your Honor a sense of what our defense is and what this trial date would be and how the motions would allow for the trial date, which we would propose propose would not be in December, but somewhere around January 12th. But if the court would allow, I shared what our defense theories were with the government counsel in a letter asking for documents and preservation of documents. But if I could have a brief moment to outline how we view the case and how we would stage motions in order to get that trial date. Judge says, oh, well, all right, well, let's do this in a procedural manner here that makes sense here. My first question was whether or not we need to set this case within the speedy trial deadline or outside it. And what I'm hearing you say is that you're asking for a date outside the speedy trial deadline. Is that correct? Yes, Your Honor. Except that we would propose motions be filed. The government would propose motions begin to be filed on October 20th and a brief through November 20th so that the 31-day exclusion that we don't count against the clock would move the speedy trial clock, putting aside the time it takes to decide the motion. It would push the speedy trial clock into January because we're not going to count that against you because the defense is working and you're working, and we're just going to say the defense wants more time and the prosecution wants more time and they agree that we need this time. So we're just going to exclude it from the speedy trial calculations. So it won't be in December. We'll push it back. Judge says, all right, have you discussed a potential trial date and a potential motions schedule with the government? Or is this proposal that you're making for the first time here? Well, Your Honor, defense, we've briefly discussed it, Your Honor. The first substantive contact I've had with the government was yesterday afternoon. We had an exchange of some requests back and forth, and I had told them that I would give them the responses if I had the answers to some requests I made, which we did not get substantive responses. So before court, Mr. Lemons, prosecutor, says, I'll say Mr. Lemons, and actually the whole team spoke. I'll just say him, but I told them that in our view, we wanted to get this moving, and we would like to propose dates starting with October 20th through November 20th for briefing, realizing that we haven't received a single piece of paper of discovery to date. We still haven't been told who person 3 and person 1 are, and we don't know the nature of the charges below those charges. And we've been asked whether we have security clearances, but within that, my client Comey is anxious to get to a speedy trial. And we thought that by proposing a speedy trial motion schedule from October 20th to November 20th, that would allow us to get to the trial date of January 10th, 12th. So defense says, I will be clear. That was my proposal. We spoke about that 15 minutes ago. They didn't agree. So I think that's a fair statement of where we are. Looks over there. About right. Judge says, all right, well, let me hear from the government, Mr. Lemons, with regard to the government's position. Now, first, with regard to whether this case should be set within the speedy trial deadline or not. Prosecutor Lemons. Your Honor, we're in agreement with the defense that this trial should not be set within the speedy trial deadline of December 17th. Okay, so that's fine. Kick it out. Judge says, all right. And that's because you believe that the issues are so complex or that there are issues that make it impossible to resolve this with the trial date in December. Prosecutor Lemons. That's part of it, Your Honor. A part of it is obviously honoring the defense's request for the later trial date and understanding and wanting them to have the time adequate to prepare for trial. But also, and it's no discredit to Mr. Fitzgerald, he's not, and we're just getting our hands around the discovery as well. There is a large amount of discovery, which also includes classified information, and that kind of gave rise to the classification question to the defense counsel. So for those reasons, Your Honor, we think it is appropriate for the trial to be set outside of the speedy trial clock. Judge says, all right, well, I will tell you, I'm a little skeptical of that. This does not appear to me to be an overly complicated case. There are 2 counts. It's a discrete set of facts. I appreciate, though, and I respect counsel's desire to be well prepared on both sides for trial. And had the parties come in here and asked for a trial date within the speedy trial deadline, the court was prepared to give one. Now, having said that, I'm not going to force you to trial in December if both sides don't feel that they can be ready. And so we can address that in terms of how much more time is needed. Now, the issue of classified information is an important one, Judge says. And I'm curious as to the government's view as to what role that will play in ultimately how this case gets tried. Do you believe that it will be and play a significant role? Prosecutor says, Your Honor, the government's position is that at this time, there is a significant amount of classified info, and our intent is to handle it as efficiently and expeditiously as possible in communicating with the defense, Comey, but also with an eye towards declassifying the information as opposed, yeah, let's go, baby, that's what we want, as opposed to what could come with presenting classified information at a federal criminal trial, if that makes sense, Your Honor. Makes sense to us. We're down for that. Yeah, let's get it declassified, all right? Don't go off the record. Don't keep it under seal. We don't want any of that. What is it? Judge says, all right, defense, Mr. Fitzgerald, let me ask you about that and whether that's an issue you have discussed on your side. It sounds like there has not been a discussion about CIPA, the Classified Information Procedures Act, how you handle it, or how classified information would be handled. Do defense counsel all have clearances at this time to look at the docs? No, Your Honor. Ms. Carmichael has a clearance. I had a clearance when I was with the government and to a high level. I have not had that clearance since I left the government. Mr. Comey himself had a high level, but does not have that clearance anymore. The first time that this CIPA issue was raised was yesterday afternoon. We have discussed it and we are a bit confused, says the defense. We see this as a simple case as well, Your Honor, and both, we don't see how this could be walking into a buzzsaw of classified information the way other cases might. We obviously still haven't been told precisely what is in count 1 and count 2. But in addition, frankly, we would have thought in the normal course, when the government brings a case, they address the classified information issues ahead of time, coordinate with the national security section, and have a plan. And frankly, we feel like in this case, the cart may have been put before the horse. horse, and my client would not like to wait around unnecessarily while they go through things we think that they should have been done before. And just to be clear, the reason we wanted the trial date in January versus December isn't to prepare for trial. It's that we'd like certain dispositive motions addressed first, in the hope that a trial would be avoided. And I can explain that later. But we think the classified information issue should be manageable from what we see of the charges. And we also think that a Section 2 conference might be appropriate in short order as well. Judge says, all right, well, in light of the joint requests of the parties to set this matter outside of the speedy trial deadline, the court will do so in the interest of justice, especially in light of the government's representation about the possibility of classified information playing some role in this matter. So I will set the matter outside the December 17th deadline. Now, the proposal is January 12th, and I think I would like to move that up by a week to January 5th, looking at his calendar, unless I hear a strong objection from counsel. No objection from the government, Your Honor. None from the defense. Thank you, Judge. And let me just ask again. We're at an extraordinarily early stage of the proceedings. How long do the parties believe a trial would last? Defense says, well, I would like to hear from the government, Your Honor, since they know who person 1 and person 3 are and the charges first. Well, it's the government's burden, so why don't you tell me how long you think the trial would last? Prosecutor Lemons. Your Honor, the government's position is we can complete this trial from the government's perspective in just 2 to 3 days. Pretty simple. Defense says, that sounds right. Our best guess was 2 days, Judge. Court says, all right. Well, that would certainly be consistent with the way we try cases here in the Eastern District of Virginia. So I will set the trial date for a jury trial on January 5th, 1 day before January 6th. Very poetic. Now, let's work backwards, says the judge, to address a motions schedule that is both expeditious but also realistic, and we'll set aside the issue of the classified information for a moment. That's going to require a more involved discussion. So, defense, Mr. Fitzgerald, if you would like to come back to the podium, please. You've suggested October 20th for motions to be filed. Is that correct? Yes, certain motions, Judge. I think that October 20th schedule, I would suggest, would be for the first tranche of defense motions, which would principally consist of a vindictive prosecution motion, which is rich, coming from Comey, who rigged intelligence reports to go after Trump. Vindictive. And whenever I say vindictive prosecution motion, Your Honor, I mean both strands of the vindictive prosecution doctrine and the selective prosecution doctrine. So it may be a retaliatory prosecution where our view is that the prosecution was brought at the direction of President Trump to silence a constant critic of him. Now, at the same time, the defense says, we would also like to bring a motion to challenge the lawfulness of the appointment of Miss Halligan as the U.S. attorney because we think that's an unlawful appointment. And we think that those two motions go together. And we think that they're critical for reasons I could explain. And if we did those motions on October 20th, I would propose that if the government responded 14 days later, that would be November 3rd. And then if we responded 7 days later to that, that would be November 10th. And then, Your Honor, we could go to the second round of motions, which we would write while they're responding to ours. And I think those motions, we're a little less certain of precisely what those motions would be, but there might be a Bronston literal truth defense motion. You know, what he said was literally true. There may be a grand jury abuse motion, outrageous government conduct, but those motions would be addressed to the indictment. And we would propose to file the defense briefs on October 30th. So we'd file one set of briefs and then 10 days we turn around and file the second set. The government's response, if it's 14 days later, would be on the 13th and our reply would be on the 20th. And those sets of motions would collectively be fully briefed by the 20th. Judge is making notes. Okay. All right. Well, let me ask Mr. Lemons, any objection to proceeding in that fashion? Sounds like they worked a lot of this out before. No objection from the government, Your Honor. Sounds good. All right. Well, I think that is a reasonable schedule, says the judge. And I think it does make sense to do this in two different tranches. Ordinarily, we would have a single motions hearing, but there are a variety of issues to address. And I think it can be efficiently dealt with that way. There is an additional wrinkle or complication, says the judge, but that will be easily dealt with, which is that any motion to disqualify Ms. Halligan will be heard by an out-of-district judge. That is the process that has been followed in New Jersey and Nevada, and this court will follow that process here, which means that a request will be made to Chief Judge Diaz of the Fourth Circuit, and then he'll appoint an out-of-circuit judge only to address that issue, which is curious. That will not affect the scheduling of the trial or the resolution of any other motions. And of course, it will be up to that judge to decide the particular scheduling in that case, and certainly your proposal of the 20th will be reflected in this order. But it would be up to that judge to ultimately decide on how to handle that specific issue, so that judge might schedule other dates that you have to abide by. So the court will proceed in that fashion. Now, as for oral argument on these motions, if I heard correctly the dates, and let me look at my calendar here, says the judge, the briefing would be complete on the first tranche of motions by November 10th. And if that's the case, the court is inclined to set an oral argument on the 19th of November, which would then give us a prompt opportunity for resolution of those motions by the 19th. Judge continues. With regard to the second tranche, which would be filed starting October 30th and fully briefed by the 20th, that puts us right in the middle of Thanksgiving. Although certainly there is precedent for this court holding hearings during that week, I'm not going to put you all in that position, but I will set a hearing for the 9th of December. Everybody's looking at their calendars. So oral argument then will be on November 19th and December 9th with a trial date of January 5th. So I think that addresses the scheduling of the trial and the motions. Yeah? Now let me ask, and I think I know the answer. Oftentimes sometimes in arraignment, I will be handed up a joint discovery order that you've been working on. I take it that the parties do not have such an order yet in this case. Is that correct? Prosecutor: that is correct, Your Honor. All right. And I take it there has not been a substantial discussion of submitting a joint order. Is that correct? Prosecutor says: Your Honor, we have circulated, I believe, a standard that's often used and familiar to this district in terms of hammering out the details. The defense and the government have not done that yet. We discussed being able to do that maybe today or at a later date, but I also don't want to speak for the defense, Your Honor. Thank you. Defense: Your Honor, we have received a draft last night at about 11 p.m. from them. I confess I was asleep, but I did meet with the prosecution team and we're happy to discuss it further. We would like to move that along just as much as everyone else. All right, says the judge. Well, this is what I'm going to do. I am going to require that you have a substantial and meaningful discussion, you two, about whether or not you can come to an agreement on a comprehensive discovery order, what each side is going to give the other side. And if you cannot do that by the end of the week on Friday, I will require you that you each submit your own proposed order by the close of business on Monday. You may submit a brief along with that order, setting out the reasons and the justifications for asking the court to adopt whatever it is you're proposing. And I don't want briefs of more than 10 pages on this issue, so keep it tight. The court will then issue a discovery order if you cannot come to an agreement. So I want to get that issue resolved promptly. Defense says: Your Honor, there's one matter that I should have mentioned. In order to make our deadline of October 20th on the appointment issue for Lindsay, we would like to see the appointment papers forthwith. We don't want to be shooting at the wrong target. So, the documents about Lindsay Halligan's appointments. He's like, we need of this discovery, we need that like now. So given that most appointment papers for U.S. attorneys are a page or two, we would ask if you could give that forthwith so that when we appear before whichever judge is designated to hear that motion, we can be drafting our motion right now. But we want to know what we're shooting at. Now, I am sure the government will be able to work out an appropriate accommodation, like looks to them. You can give them her appointment docs, right? Yes, Your Honor, absolutely. Happy to. All right, very good. And again, the court is not asking for competing discovery orders. I don't want those. The court wants to make sure we resolve this promptly. So if you all can, through professionalism and courtesy with each other, work these things out. That's the court's strong preference. Nobody wants to do extra work here. And it's often the case in this court that the defense counsel and the government can do that. I see no reason why that can't be the case here, but I'm not going to let things linger. So if you have a meaningful discussion and cannot reach a full agreement, that's the other option. You can submit a joint agreement as to what you agree to do and then brief for the court those few areas of disagreement for the court to resolve. We'll make sure that it's done promptly. In order for the defense to be able to file motions, they are going to have prompt access to all of the necessary and relevant information that relates to these motions. I will not, says this judge, slow this case down because the government does not promptly turn everything over. And the government should have every interest in doing that. So you guys better work fast. Prosecutor: Understood, Your Honor. Yeah, thank you. Judge says: Are there any other housekeeping matters with regard to motions that we need to discuss at this time? Defense: Your Honor, I will raise it with the government. I just want to make sure we expedite the process of seeking clearances. If I have to go through the court security officer, if I have to go through the government, I just want to move that along too. Judge: Yes. In addition to discussing the discovery order, which includes the whole range of Rule 16, Janks and Giglios and experts and all these important matters, and all of the other things that are addressed in that standard order, I'm also directing the parties to have a discussion immediately about access to classified information, making sure that the Department of Justice does everything in its power to ensure that defense counsel is cleared to view those documents. I know Ms. Carmichael has had a number of national security cases in this district in the last few months and has a current clearance. I cannot imagine that it would be difficult to arrange that clearance for Mr. Fitzgerald, who has long history with the Department of Justice and I'm sure has had a clearance for many, many years. And I want you all to discuss the SEPA procedure and submit a proposed joint schedule as well, saying the government is going to be under an enormous amount of pressure to figure out what really has to be done here. Why? You are the only ones with access to this classified info. So we are going to find out absolutely as quickly as possible if there is classified information that needs to go through the SEPA process, or the government has within its power to declassify documents and take that issue away altogether and turn that information over in the regular course of discovery, which is what I really hope they do. Just declassify it all, let us see it, file it openly on the public docket. This is a court that has dealt with these issues for many years, is familiar with them. There should be no reason that this case gets off track because of the existence of some classified information. And this kind of makes me, if the judge comes back and says that the prosecution is not producing the materials expeditiously enough, then the judge might sanction them and say you can't use those materials. It's kind of like laying the groundwork for that. Saying this is a court that has dealt with these issues for many years. Either it's not relevant to the case, or it can be declassified, or we're going to go through SEPA, the fastest SEPA process you have ever seen in your lives. I like that. That's great. All right, that's cool. Shout out, Judge. We're not going to delay this. Anything else with regard to discovery or motions? Anyone? I appreciate the efforts of counsel to work together to find dates that are realistic, but also expeditious. Nothing further from the defense. Thank you, Judge. Nothing from the government, Your Honor. All right. Well, let's turn to the issue of detention now. Should we lock him up? I assume the defendant, James Comey, was served with the summons and has appeared today that the government is not seeking detention detention. Is that correct? That's correct, Your Honor. Wah, wah, wah. And the government has received a copy of the pretrial services report, right? And do you have any objections, modifications, or changes you wish to make to it? So pretrial services, so James Comey, he would either meet with them, his attorneys, or they would provide some information and they would write a report to the judge about his flight risk, his, prior criminal charges, any dangerous allegations, stuff like that. Then the judge could make a decision on whether to hold him in custody or not. Any changes to that? Are you happy with this report? We have no changes or modifications, Your Honor. All right. Thank you. Mr. Fitzgerald, defense. Let me confirm that you've received a copy of the pretrial services report. Yes, I have. And you've reviewed it with your client and you have no changes, modifications, or objections that you wish to make. None whatsoever. Very good. Well, then I will adopt the pretrial services report and the information in it and the recommendation made, and I will place Mr. Comey on a personal recognizance bond that he can sign after the court. So no money. All he's got to do is just sign a promise to appear. And of course, I require Mr. Comey to return for trial and any motions hearing. I don't believe that there are any other conditions that have been recommended or that are necessary in this case. The final issue we have to address today is the Due Process Protections Act. Now, because this is the first appearance of the defendant with counsel, this court is required by the federal rules of criminal procedure and the Due Process Protection Acts to remind the government of its obligations under Brady versus Maryland, which requires the prompt disclosure of all material exculpatory evidence, and that failure to turn over this evidence can result in sanctions and even dismissal of the charges. Now, let me confirm the government understands its obligation under Brady, and you intend to abide by its constitutional duties. Yes, Your Honor. The government understands its duties and intends to abide by its constitutional duties. All right. Thank you very much. And pursuant to the Due Process Protections Act and the federal rules of criminal procedure, the court, in addition to doing this orally, is required to enter a written order. And that order states as follows. The court orders the United States to adhere to the disclosure obligations in Brady versus Maryland and its progeny. It instructs that the suppression of prosecution evidence that is favorable to the accused violates due process. You got to turn that over. Failure to adhere to this, serious consequences, dismissal of the charges, sanctions, and more. I got to read this by law. All right. Is there anything else further I need to address with regard to this matter this morning? On behalf of the government? Nothing further from the government, Your Honor. Thank you. Mr. Fitzgerald, anything on behalf of the defense? No, Your Honor. Thank you very much. All right. So the trial has been set for January 5th. The motions scheduling has been set as previously articulated. I will issue an order that reflects the dates that we have discussed. Now, in a moment, we will recess court. I'm going to ask that the members of the public promptly exit the courtroom and go directly to the elevator so that we can clear this floor. I will ask counsel to remain at counsel table until the courtroom is cleared. And I want to thank the marshals and our court security officers and my courtroom staff for helping make this a very smooth proceeding today. Court will be in recess until tomorrow. Thank you, counsel. Signed and sealed and brilliantly transcribed by Diane Salters. Shout out to our court reporters who send me transcripts at 11:30 at night. We love you.